Good morning, Karen. How are you?
I'm well, thank you. How are you?
Look, despite all your hints about leopard skin, I chose not to buy a leopard skin coat.
See, look at this, guys.
I stayed in blue, conservative blue as always.
I will say though, you did consider it briefly. You sent me a link with a leopard print jacket.
I did, yeah, I did.
It was Versace though, so anyway.
Yeah, I couldn't afford
You're gonna go all the way
Anyway, next financial year. And we're in the new financial year,
yes.
Which is exciting as well. And
some big news for you. Your team looks a little bit different on Monday. Better though.
Yeah, I know. We've got a Sydney business, a really clever Sydney business that comes in and merges with us. So we'll be strong up the eastern seaboard, which is really lovely. And they're a very clever capital raising IP business full of people who share very similar cultural sort of imperatives to us. So it's been a lovely process, very fast and very busy, running towards the end of a financial year. And I was thinking, in the last 2 days, I've been driving all over the country, so the people in Geelong, Warrnambool, Colac, hi. It's been a lovely thing to be able to do, but a lot of our friends elsewhere just can't because of lockdown at the moment.
Yeah, no, that is tough. I spoke to a couple of clients this morning from different states as well, and they're just absolute frenzy.
Yeah. It's it's not a topic for today, but I think we know in workplaces that health comes first. So and it's probably our message that we say repeatedly that someone's health comes before the business, because actually without that the business fails. And it's probably disappointing that we have so many different reactions to the same public health issue because of the politics of public health in Australia. And it's appalling. And we really, if we could ever get the leverage to get whatever is necessary for the federal government to own this and say, look, we will have a single messaging, we will have a single process. It will be based on public health principles. It won't be based on whatever the spin is that week. As a country, we need to respect public health and put our people first. And at times, I think, it doesn't matter which political perspective you come from, we're failing.
Yeah.
And we're in a place now where we didn't clamp down quickly, and the whole of Australia is moving towards lockdown because of political, not public health issues. So let's move on to some interesting things that are happening. That's my sobering bit. You can tell it's the end of the week and the end of the financial year.
Uplifting, Andrew.
I know, I'm not uplifted. It's the end of the financial year. I'm exhausted. I think a couple of things, just some basic facts for you. The high income threshold has gone up from 153,600 to 158,500. Just to be clear about the high income threshold, that excludes you from the unfair dismissal regime and also from award coverage potentially, as long as the enterprise agreement doesn't intervene and hold you back into those things. Okay, so just be aware 158,500 is the high income threshold, but you can still be subject to an award conditions if you've got an enterprise agreement that you respond to, but you will not be able to bring an unfair dismissal claim. So be aware of that, and there's some calculations that aren't including that, like private car use and a whole lot of things. But if you speak to Nina, who's our expert around that threshold, she'll set you straight away. The other thing is, when that happens, the maximum income the maximum income compensation threshold has moved from 76,800 to 79,250. So that's the maximum amount that any person can get an unfair dismissal. So I would just keep you up to date with that. Interestingly, under the changes in restraints, New South Wales is you must not come to work unless it is absolutely necessary. So they've restored that part of the legislation, which means we can't require people to return to work for this period of time. So for our New South Wales people, please be aware of that. And let's just jump into the case law, I think.
Okay.
Because we've got quite a lot of it this week, and it's really interesting stuff. First one is about alcohol and drug policies. The case is Rushton and Giacchi. Interesting case, not new law. By the way, there's no new law today. There is just cases which really help explain what is already established law. So it's useful in that process. Giacchi had a really good drug and alcohol policy that had been properly consulted upon. So people knew about it. They understood the risk that it was trying to prevent. And it was calibrated well against that risk. It had a strong rehabilitative element in it. It wasn't a first strike policy. It's not a mine. It's not a logistics business in the sense of carrying highly dangerous goods type logistics business. So this was a business that had a very well calibrated, prescriptive, cautious, rehabilitative policy that people understood. And the guy failed and had on a number of occasions failed when he came on to do the alcohol tests. And when he did do it in the evening, when he did do it later in the day, he had a high alcohol level. And when he had a 15-minute break, it had gone down a little bit, but not enough. They stood him down. They investigated it, and he said that he was taking lozenges that created it. Well, I'll tell you what, there's not that much alcohol in the lozenge. You'd have to swallow half a factory of lozenges to get drunk. And then he said he had a cigarette smoke in between the 15-minute gap, and that all affected it. And the Fair Work Commissioner said, 1, policy is a good policy. 2, companies behave really well. 3, I don't believe anything you say. 4, I uphold the termination. But it comes back to what we say about policies, doesn't it, Karen?
Yep, absolutely. Make sure that it, in terms of particularly with drug and alcohol policy, that you genuinely consider and identify what the risk is, so that it is appropriate. So in terms of what you said earlier, whether it's appropriate for an organisation to have a zero tolerance policy, like one strike and you're out versus something a bit more layered. And I think the thing with policies as well, Andrew, I'm of the view that generally when I craft policies that they're very simple and they're overarching because there's guidance and procedures to support that as well. Drug and alcohol is one that I would normally treat as an exception, and where it does need to be quite prescriptive, and well, it is prescriptive and very clear in terms of what the process is. Having said that, because of that though, the consultation and engagement around that piece is very important.
Yeah, and look, at the Fair Work Commission has repeatedly said your failure to engage and consult in mandating a process clearly is unacceptable, because people must know what's coming towards them. They must understand why it's coming towards them, because people don't comply because there's a rule. People comply because they understand why there's a rule.
Yep.
Next case is Steel Construction Australia in Guildford. It's a case we've talked about once before. It was where a project manager or building manager brought on labour hire. One of the labour hire employees fell through a void. The building manager clearly had the responsibility of doing the safe work method statement, didn't identify the void as an issue. Guy ended up with serious spinal injuries, and for reasons which only their solicitors and they will understand, they then appealed the decision which said, don't be an idiot, you're responsible for the labour hire employee. And the appellant division said, don't be an idiot. Every person under safety law has a responsibility. So labour hire person has a responsibility, company who hires them has a responsibility. But the court went on to say, but what are you talking about? You're actually the business manager. You are the safe work method statement person who was to identify the risk. You are the person in supervision and control of the site. How do you think you don't have a responsibility? And I feel the same. As I'm reading the case, I went, what bickies are they eating to bring this case? But the bottom line is, I want to be very clear. Labour hire contracts commonly have this huge argument over the allocation of liability around safety that actually has no effect at all on safety prosecutions because it's a statutory base, it's not a contractual base. It is a very good discussion, and when you're working with a labour hire business, to talk about that issue, because what it hones down on is, well, what is the supervision and management of that person? But the reality is, when I hire a labour hire person to fit them into my business to carry an activity, I can never get away from the supervisory responsibilities. So again, it's not magical law, but it seems to be to these people.
Yeah, absolutely. We've mentioned this, it's resurfaced a couple of times before, and I think my messaging around this is certainly when you're engaging labour hire agencies, that these conversations and how the mechanisms of how this works, but around supervision, induction, who has what role in terms of the level of responsibility, so there is no doubt, because it's not everything's fine until we have an incident. That's
right. It's all good until someone loses an eye. Yeah. And our last safety prosecution we did involved a labour hire business who utilised the induction of the principal. And, it seems so nice, you could say, but the labour hire business did the induction. Well, of course they do their induction. They're their employee. But when they come onto your site, they are a person on the site. They're a third party you can be in. So in Victoria, Section 23, you have a direct responsibility for them. Just remember, the safety legislation doesn't devolve responsibilities. It sets out and identifies everybody as responsible. So please, there's no magic in the case, but we shouldn't keep having these cases, is the short answer. Next case is Deshong and the Workers' Comp Regulator. I'm doing this because in the last week, I've spoken to about 4 or 5 people who've had their claims, their stress-based claims accepted when they didn't do anything wrong. So they're all in relation to performance management conversations. And remember, reasonable management action is one of the 3 defences to a stress claim. The 3 defences are there is no psychological injury. And we said before, once you get to conciliation, there will be a general practitioner who says there is. So don't get too excited about that. It didn't happen during the course of work. Now, as I've said to you before, we need our supervisors and managers identifying changes in people's behaviour that relate to outside activities, because as they cross the threshold into your workplace, they may be carrying terrible grief or pain or anything. But if work impacts that fragile mental state, it's work related. Okay, so that's the second. But the third part is reasonable management action. That has only two elements. One is that the action you take in performance is reasonable and that it is done in a reasonable way. It is not, as the insurers all say, that you did exactly in accordance with the policy and process. And there's been some terrible acceptance of claims recently by regulators. And in Victoria, it's very difficult, because what drives the insurers in Victoria is that the person who makes that decision is in fact the state government. And the state government incentivises acceptance of mental health claims because it's a policy issue. So at the very time you're going to see your insurer, they will earn more by accepting a claim than they will by rejecting it, depending on the time of year and the bonus that sits behind it. Okay, because that's how policy works. And that's why you must have Kim driving that question of saying, this is reasonable management. Yes, we didn't quite follow the policy, but that's not what it is. And here is the case, Deshong, that talks all about it, because here is a person who alleged bullying. What they did is direct her not to go to the same workplace, but to another workplace. She said, well, this is wrongful behaviour. It's not reasonable management action because you're treating me badly because I raised this. And the organisation, and this is the findings that are important, were not completely perfect in what they did, but they were reasonable, fair and generous. They were kind in what they did. They focused on the issue on her health. The change was designed to protect her health. And the court said, well, everything that you've done in this process was done for a good reason. And it was done in a reasonable way. And there were some imperfections along the way, but that doesn't invalidate reasonable management action. Now, if you have a circumstance investigator come in, any failure in your process, they will say is a breach of reasonable management action. It's rubbish. It's completely wrong at law. But if you do everything right and you don't have Kim at the end, it's going to go badly. But if you don't do everything right, if you don't get this generous, health-focused process, which is fair, which offers people health support all the way through, if you don't do that, you have no chance at all, because it will fail the second test of reasonable management action. The first test is, was it reasonable to do it? Yes. Was it done in a reasonable way? No. So Deshong is a case worth reading, and there's be some case notes coming up. In fact, I saw Ness's article. Ness and Kim did a really good article that'll hit the airwaves in the next few weeks on our website. So watch that space.
Yeah, and Andrew, I think that the key takeaway there, at least from my standpoint, is around the reasonable management action. When we've got a scenario, we're presented with that type of scenario, it is critical to take a step back and really and thoughtfully consider what is the problem that we're trying to solve here. What is the actual strategy? Everything that you've just covered off there you need time and space to think about that. You need to seek counsel advice on that. So.
And the last part is, please be generous with people with health-related issues. Don't write "we refer to" letters. Be kind. Has the same effect, but actually they're your people, so you should treat them well. And if you don't treat them well, you're really creating a health issue in yourself. Now, not surprisingly, because Karen and I have been in the green room beforehand discussing this, we've gone a bit further than we meant to. So I'll jump on to the next subject. And the next subject is, what happens if someone is convicted of an offence and placed in jail? What does that mean for their contract of employment? I'm raising it because last week we talked briefly about a concept called frustration of contract. Frustration of contract is where a person's termination occurs as a matter of law because the contract cannot be fulfilled by something that's no one's fault. And the classic example of that is to get to a particular property, you have to go along a road and there is a huge tempest and storm that tears the road up so you can't get to it. So, act of God, under insurance policies, sometimes you'll have it in force majeure clauses, whatever it is, that's frustrated the capacity of the contract, so the contract ends. So there is a whole lot of case law that says when someone does something that gets them to go to jail, that it may frustrate the contract. And what you do is write to them and say, look, your incarceration has meant that you can no longer undertake the contract with us. We've accepted the fact that you can't do that, and we note that your employment has been terminated as a matter of law. not at the initiative of us. Now, why did not the initiative of us? Because it was at our initiative, it brings in the unfair dismissal regime. Okay, so it is a jurisdictional method of avoiding the unfair dismissal regime. Can I say the difficulty with that is it depends which side of politics the commissioner comes from. Now, that's probably an unkind way to say it, and I probably wish I hadn't said that on live air. But there are many commissioners who say, look, the person still has a capacity to perform the work, but they're just in jail. And in any event, they did cause it, so it can't be frustration. So therefore, it is an unfair dismissal claim, and you can't get out of it jurisdictionally. But what the courts have repeatedly said is, if a person can't come to work because they've been locked up, it is a valid reason.
Could work remotely, Andrew.
Yeah, that's right.
We're moving towards this hybrid model.
Can I just get through these and get to my laptop? Yeah, well, so the answer is, what is the period of time over which you could say, well, the person's no longer able to do their job, and it's either a dismissal, a proper valid reason for dismissal, or it's a frustration of contract. You'll be completely surprised to learn there is no guidance at all in the case law. My feeling is, and the advice I give, someone gets locked up for a couple of weeks, unless the nature of what they were convicted of goes to the heart of their contract with you, which is the Rose and Telstra argument we have every week. So unless it's one of those issues, that's not a frustration of contract. It's not a valid reason to terminate, unless they've lied to you about it. Remember, lying is always serious misconduct.
Yep.
If you're looking at 2 to 3 months, I think at that stage, you're pretty safe to go, look, I'm sorry, it's over. And the reason you're pretty safe is it's unlikely they'll lodge an application. that's the only reason, because the case law provides you with no real guidance. Okay. But look, there's a really good article that Julia and Matt are working on, which we talked about last week, and they've put a lot of work into this article. So when it comes out, we'll make sure you will get a great article on criminal behaviour, out of work criminal behaviour, and the effects it has on employment and what you can and can't do. So, Karen, I'm going to hand over to you. Last week, we talked to you about the new standard that's come out in New South Wales around psychological risk. And I thought, as I read through it, thousands of pages long, and knowing the psychologists who prepared it, I mean, really interesting stuff, but almost impossible to follow.
Oh,
Karen, over to you. Make it simple.
It could be a bit of a paralysing read, Andrew.
Can you bring up Karen's incredibly helpful sheet? There we are. Look at that incredible. Look at that face.
Oh, look at that.
Sad face.
Oh, yeah, a bit worried, I would call it. But anyway, not so much. All right. So psychological safety. Yes, I did go through the code, and it was a helpful read. There is a lot in there for those.
Karen has trouble sleeping. It worked really well.
Okay. Thank you, Andrew. So look, what I read it, and I'm like, okay, so how do I present this to you all in a way where it will prompt you to think about in terms of what you've got in place, what you're doing, and how effective all that is working for you. So I think these are a couple of questions I've put together, and I put in a little bit of a chart so you can mark along there organisationally how you think you're going, whether or not it's not something that you've considered or haven't started work on versus something that you're progressing and doing something about, or are doing something about. And then the last part of it, the smiley face there, suggesting that you're under control. I think that if I want to spend a moment to talk about this, Andrew, I want to focus on the organisational, the safety culture and the organisational attitude towards psychological safety. Now, I don't know about you, but I've been hearing probably over the last 12 months, the term being thrown around fairly loosely. Okay, so psychological safety, what it means and what you should be doing. This psychological safety is part of safety. Okay, it's not an add-on. This is part and parcel. And I'd like you to consider organisationally, where are you at with your safety culture? Because this should feed in and align in terms of prioritisation very much, that should be part of it as well. So
can I just say, Karen, we see fashion or internal marketing around various safety things. We've seen the farcical thing of zero harm, which damaged more people than it ever hurt. We now see psychological safety training, which tells people what mental health issues are. Actually, none of this is hard if you go back to what it reasonably practical is. Yep. Is something a hazard? Like this isn't, and we drop the bomb. This isn't magic. Is something a hazard? Yes. What is the risk of that hazard? What do I need to control that, to prevent that from occurring? And what resources do I need? It doesn't matter whether it's psychological. You don't have to be a clinician to do this.
Yep.
You just got to do the right thing, which is identify if there is a hazard. So I'm sorry if I'm jumping in, but I guess I'm sick of fashion and safety.
Yeah. I hear you, and I feel very much the same way. So look at that. When I speak with clients, and something I've learned in my previous career is around safety culture. I see it as 5 stages. We call it the 5 C's in terms of in terms of your safety culture. Are you at a crisis point? Are you at a stage where you're in control? Are you at a place where you're compliant? And then we move on to commitment, and then we move on to culture. So where is it that you sit in terms of your safety performance and your commitment there? And that's where psychological safety is too, by the way. It's not a separate strategy altogether. So with that, have a think about some of these questions I've put forward and how you think you're going with that. The other part of it in terms of who has the responsibility around safety. And I'm not talking about the day-to-day stuff. I'm talking about the overall strategy direction. Who's got what roles by way? Who are the executors, the influencers, the decision-making people, rather than, is it a matter of like the site manager picking up or reading an article about psychological safety and goes, hey, we're going to do something. Like it needs to be much more, it's driven by the safety direction and strategy. So there's a couple other things there that are a bit more straightforward for you, but I hope that's helpful for you as a prompt. And certainly if you want to read more and in terms of more some practical guidance and suggestions, the code is there.
Yeah, and look, I think for Karen and I think this is a great chart because this is the ready reckoner. And we talked about this as we were working on it, as Karen was working on it last night. What I wanted you to have as a ready reckoner, I want safety to be simple. I want to stop all the noise and all the crap that sits around safety and all the bureaucracy that sits around safety. Because the one rule about safety is if any block appears before safety and operations will win and safety will fail. So I didn't produce this. Karen's much more skilled than me. Karen produced this as a ready reckoner, and I want you to do it. And I want you to sit down with your management group and say, we're going to do 10 minutes. And just see where you turn up. Are you red? Are you yellow? You got a bit of green? Or do your gap analysis and go, okay, well, this is our focus. This is a great little document.
It's a great way of having a conversation at the leadership and management level.
But no more fashion, okay? Let's just get back to what the law is. Let's get back to looking after people and caring for people, and let's stop all this crappy noise and silly photographs and just go, actually, our job is to care for the people who work for us. Our job is to identify what hazards are so they don't hurt people, determine their risk. Like, there's none of this is magical. No. It's actually what the law says. And it's what you do for someone you cared for. And the last question I want to ask you is, and I know I ask you every now and again, if you see your child about to walk across a busy street, do you grab their hand and say, wait? If you see your work colleague about to walk across the street who's talking on a phone and there's a truck coming, you go, oh, that's their problem. Well, I can tell you now, morally, that's a pretty offensive path to take.
Absolutely.
All right, let's jump on, Soph, if we can go to the new case study. All right, and this is a 2-page case study, I hope. Bevan drove a truck for fast-paced deliveries. He was arrested on Saturday night for dangerous driving and driving under the influence. He was bailed Sunday morning. On his lawyer's advice, he pleaded guilty first thing the following Monday and was sentenced to 3 months minimum term in jail with a top of 12 months, and his licence was suspended for 12 months. Bevan failed to disclose the incident to his employer, but the Herald Sun ran a 2nd-page article stating fast-paced delivery driver pleads guilty to dangerous driving and driving under the influence. This is how Fast-Paced found out about him being in prison. Next page. Fast-Paced sent him a letter saying the imprisonment had frustrated his contract of employment, and they accepted that frustration of contract. He had only 15 days of accrued leave. In other words, when he went to jail, he would have exhausted that leave pretty quickly. Fast-Paced had a clear wellbeing and health policy, both internally and published to clients externally, saying the drivers and business were respectful of road rules and always acted in healthy and responsible ways. This was a brand statement and differentiated from other delivery services. At the time of employees commencing work, they advised it was a clear condition of employment. They must not drink, drive or drug drive whilst employed, even if it's out of hours. Poll. Let's go. There it goes. We're up and running. Yes. Try to stay awake. It's so hard. End of financial year is just a killer time, isn't it? Normal business. You're just running to the wire. It's yeah, we're here. We're good. How long? I think people are going really well, actually.
Yeah, no, pretty good. Let another 5 seconds. So we'll close it off. Okay. 3, 2, 1. Thank you so much. I'm ending it, and we are sharing results now. All right, and
Okay.
oh, okay. Sorry, you can't see that. Okay.
All right. So look, first question was the employment contract frustrated by Bevan's employment. Look, there's a really strong view amongst you that it is. I think it is too. It's such a long period of time, depending on whether it's a blue or red colour of the commissioner's tie. You mightn't get up on frustration, so you'd argue that as one thing as a jurisdictional argument. But yeah, this is pretty fundamental. But the next one is the absolute killer. This is out of hours conduct that goes directly to his capacity to be a driver. And so you remember the Bogues case where Bogues said that they fostered, that was a joke there actually, fostered responsible drinking. And that was actually differentiate them between Carlton United by saying, look, we sell really good beer, they sell bulk consumable beer. But part of it was really pushing this idea of responsible consumption of alcohol. And they made it very clear to their drivers that went broader than just being at work. And the Examiner, the local newspaper in Launceston, reported a guy had blown 0.14 and they sacked him immediately. They said, well, that just couldn't be responsible driving, even though it was outside of hours. And the court said, absolutely. Remember, Rose and Telstra goes to the heart of the organisation and who they are. So there is absolutely no doubt at all that this went to the heart of the contract under Rose and Telstra. It's a valid reason and would be reasonable to do it. And the last question, which I just chucked in for fun, because this is a very real question, is licence cancellation a valid reason for termination? Well, let me be very clear about this. It would want to be in the contract of employment. If you're a driver with us, you must hold a current licence. Now, that's obvious, isn't it? But if it's not there...
Better be in the PD.
Better be in the PD. Better be somewhere. But yes, quite clearly the person can't do the job. So it goes back to it being a valid reason. But licence cancellation is something that you must have. So all those things, if you work in a school, child safety checks, all those types of things, please, please, please put them in the contract of employment. Okay? And if you do that, you don't have to think twice. But the other part is it reminds someone of what they must do. And remember, contracts are not to be kept in the bottom drawer to be pulled out when something goes wrong. They're in the top drawer and says, this is what my job is. These are things I must not do. I turn over the schedule and there is my job description. These are the things I must do and do well. And I go back to my contract, which sets out what are the common law obligations about me acting in the best interest of the business at all time. Okay, I don't have any choice about it, so I must do it. So remember, contracts are top drawer documents. They are not just to be dragged out, because when you drag them out of the bottom drawer and no one's looked at them, there's dust on them, you often find they've expired, they've got old terms in them, they're no longer relevant, the person's job has changed. Please, please. Contract management is a critical part of running a business. Now, Karen, that's sort of me on this issue. I just think this criminal conviction issue is such a big issue, and we're seeing it all the time. We're certainly seeing it in schools where people have been charged with child pornography. We're starting to see the level of regulation around creating a safe environment for children and other people growing. But what we're not seeing at all is the document management, the contractor management that sits around those issues, nor are we seeing the education to people saying, look, this is a critical function of you. When you work for us, you can't have relevant criminal convictions. You can't do this, you can't do that. They've got to know. Because it's no good the event occurring and then you're just spending money on us dealing with an unknown quantity and everything goes wrong and everyone goes, well, why are you doing it?
So in terms practically, it goes back to your contracts, checking that, making sure that they're updated and then they reflect those requirements. PDs, it's really going back to the infrastructure that you have and the processes and governance structures that you have around just knowing this, and even though it may not be an issue right now because we don't have a live case, knowing this and the sensitivities of how it will affect our business in terms of where those risk areas are, what are we doing about that? Let's not wait till something terrible happens for us to land the front news of the paper to do something.
Now look, it's school holidays for most of us. For you,
Yes.
it's working 8 jobs now instead of just 5. So best of luck while you're at home, and we'll see you next week, and we'll be a much calmer group. We won't be quite so tired. We won't be in the financial year. See you later. Bye-bye,
See you.
guys.
Bye, everyone.